because they were going up against the largest law firm in America and one of the largest law firms in the world, who was specifically empowered by J.P. Morgan and Company in the 40s and 50s when J.P. Morgan wanted to do hostile takeovers, and Davis, Polk, and Wardell, which was J.P. Morgan's traditional law firm, said that's too dirty for us. So they found this other law firm called Skadden Arps, and Skadden Arps was happy to do continuous business. So when I read that in this House of Morgan book, I was almost to the end of my trial, and I was in the part where I was writing the final brief for my court case. So on page 599 of the House of Morgan, at this juncture, Morgan Stanley made another unorthodox decision. Like Morgan Guarantee, the firm had long relied on a WASP, white-glove law firm of Davis, Polk, and Wardell, which had looked upon takeover work as vulgar and avoided it. And then it says that this guy Greenhill insisted upon hiring the experienced Joe Floam of Skadden Arps, Slate, Marr, and Floam, which is interesting because they would be chosen, by their applicability to the situation, because EMC has numerous attorneys it works with all over the world. It's a global company, so they had to choose one. It's like choosing an instrument or a tool for a task. So when you look at what Skadden Arps is notorious for and what their speciality is, doing the work that other law firms don't feel comfortable with, then their proximity to this situation and it involving accusals of money laundering and backdoors in software and all the other things that were involved, including the systematic violation of whistleblower protections, and defending that in court and thinking that was a good idea. I mean, it was a learning experience. It was a growth experience. I mean, it was a maturing experience. I spent my 33rd birthday in court. That was my first day of giving testimony. So I gave 8 or 9 hours of testimony the first day. It was a 3-day trial. And the second day, I called EMC's witnesses as my own witnesses. I gave them the line of questioning. They put their statements on the record, and then they weren't able to be used by EMC against me because they had already told the truth in court because I asked them the right questions, and the one I had to impeach using an audio tape. But the point was, they were kind of left toothless because of this move that I did where I called their witnesses as my own.
And what law firm represented you in this matter?
I ended up representing myself. Much to my dismay, after taking the case and the evidence, and including the audio evidence to numerous attorneys, including all the attorneys you hear about on TV that you might think, hey, they're someone who sticks up for the little guy, or they're always representing someone who, in these important cases, they wanted nothing to do with it, and they were point blank saying, it would cross lines. It would be a conflict of interest for them to release this information, at which point I was left to do nothing other than act as a pro se litigant to learn the legal system and to learn the rules of civil procedure and whatnot, how to present a case in court. And I'd say the weakest point was, it's hard to, when you're on the witness stand, to object because you're thinking about answering the question, and so you answer questions instead of objecting and saying, I shouldn't answer that question or whatever. So they end up trying to get you in a line of testimony and then use it back on you. And luckily, I was able to defend myself with the evidence to an adequate degree, to the point where they could not prove any of their points, and they ended up bringing these witnesses in that I used to prove my case.
What was the result of your court case?
Well, the result of the court case was, after taking, this is just, one book of the exhibits, here's another book of exhibits, there's plenty. But after presenting these exhibits, getting them on the record, and having them stand up as the evidence of the day, meaning that the other side couldn't disprove the points I was making, I felt very confident that I had won my case, because I had won in court by presenting the evidence and getting my story told without them impeaching me, without them saying that I'm lying or making any of this up. I was able to convince the judge, and the judge is like, okay. There were times I wanted to present more evidence, and the judge says, since they can't contest it, it stands as the evidence of the day, and you don't need to present any more. So when you're being told things like this, where you've already laid it all out comprehensively, I was very confident and thought, well, I did my job. At the end of the day, when the judge finally made a decision, it was about 6 months after the trial ended, and you have to do a final brief, which for me was like 300 pages. At the end of the day, the judge says in the document that they find in favor of the corporation, because the events that I claimed did in fact take place. Everything that I said in court and proved in court and put in court, including Respondent Exhibit 7, which is Project Constellation, which deals with all these experiences and lays out how it ties into a larger fraud. So that they tried to use that against me. So after presenting all this and having it there, and it's on the record, they were left to do nothing except say, what you said is true, but it happened slightly outside of the statute of limitations, and therefore I have no power as the judge to do anything to this corporation. Now, in fact, I filed well within the statute of limitations. The actions were within the statute of limitations, and the case had been ongoing for almost 4 years at that point through multiple agencies, including the United States Department of Labor under OSHA for the sarbanes-oxley regulation. That's where it has to start, and then you can progress it into court, which is what I did. And after all of that, they're left with no other option but to say, these events happened, they are true, they are factual, here's what happened, but they're outside of statute of limitations, and so there is no remedy. And so I was left with nothing.
So there's no appeals process?
Well, I could continue appealing, but after you've already seen what happened, you go in and put it all on the record, and it's all right there. They just do not want to, they're not going to decide against a multi-billion-dollar corporation whose founder is the ambassador to Ireland for President Bush at that time, right? Or I believe he might have stepped down as an ambassador at that point, but he was still Bush buddies, and Bush was still in office, so...
So you proved in court that the general counsel of EMC, Paul Dacier, to whom you blew the whistle, is the same person who ordered that you be immediately terminated for doing so? Isn't that against the law?
Not only is it against the law, but Paul Dacier, who's the general counsel for EMC Corporation, gets a salary of maybe $1.6 million a year. So his job, in addition to overseeing EMC's aviation and real estate interests, are to deal with claims such as mine. He's on the supposed audit committee of the corporation, which is mandated by Sarbanes-Oxley, which I found out does not exist. Right, and that the phone number you call is a hoax phone number and all this stuff. So Paul Dacier, when I told him that I'm blowing the whistle, I'm claiming these protections, etc., his first move was to figure out how to terminate me for cause, for what they called cause. And when I questioned them about what is cause, they said for reasons. Okay, and it came out in court through their witnesses, through people who still worked at the company, that Paul Dacier is the one who ordered them to terminate me. So, direct violation of numerous whistleblower protection laws, and other whistleblowers should know before they lose their career and their livelihood and their financial future. So
would you say then that the protection is just theater?
That protection is absolutely only theater. It's an illusion to let you think that you have some... I'm sure in some cases it is enforced, but let it be known that if you're onto something real and you have real evidence, that they are going to move heaven and earth to try to keep those things from getting out to the public. And the things that are in paper, whether it's been from the Key Tam Act, where your corporation or your employer is ripping off the government, which is 1865 put into place by Abraham Lincoln, or it's the Sarbanes-Oxley Act of 2002, and you're selling the software to these companies and telling them they need it, and then you find out that you have to blow the whistle under that act, under those protections, and that those protections that you've been educating your clients on do not exist.
So, is Sarbanes-Oxley a thing of the past, something which caused the ongoing financial depression? Or is its effect still in progress?
The Sarbanes-Oxley regulations that have been in place since 2002 are not only still in effect, but recently, December 8th, 2009, the United States Supreme Court appeared inclined to leave well enough alone Monday and not tinker with the structure of an accounting oversight board created by the Sarbanes-Oxley Act of 2002. Congress created the board in the aftermath of the Enron and WorldCom accounting scandals, giving the board broad and independent power to regulate accounting firms which had been self-regulated before. Its 5 members are appointed by the U.S. Securities and Exchange Commission, not the President, and the board's members, like those of the Commission, can only be fired for cause and not for policy disagreements, right? And so what they're showing you is that they've created this oversight board that's supposed to make sure Sarbanes-Oxley is working well, and the Supreme Court thinks it's working so well that they just want to keep it going and that there's nothing to fix. Now, I'm not part of some plan to try to regulate or like renovate or, readjust Sarbanes-Oxley. I'm just saying the way it's being used right now, it's being used as a weapon and not as a safety mechanism. And I think that's important for people, including investors and people who are being taken advantage of, to know sooner than later. I think that just makes logical sense.